Good evening, everyone. I, on behalf of Beyond Law ClC, welcome you all. And we are quite ecstatic for the fact today amongst us, we have Honorable Mr. Justice Pushpendra Singh Bhati. Of late, during these webinars, I have seen that invariably those who are joining us as a keynote speaker or a speaker, they are invariably doctor. The doctor on the academic side or the doctor on the normal side is seen, but the justices being doctor, it's a vital combination. I'm just reminded, like somebody asked that why somebody wears a black coat as a lawyer and why does a doctor wear a white coat? Then the simple logic what she gave to me and sounded something which clicked to my mind was that they said that as a lawyer, one has to have a heated arguments. And black is the best absorbent of heat and generates more of heat and energy to speak of. And why is it white? They say white is the best absorbent and it gives you a cooling effect. And the doctor, while operating or while treating, should be very cool and calm. So once we have a combination of a doctor and an advocate who turns ultimately to a judge, we can only, as I said, ecstatic and fully be geared up that there could be a session which would be very vilifying. And another fascinating fact of today is, like we once shared, that father-son had come on our platform. And it is a rare combination that a brother and sister come on a platform on different occasions and they give their insights. And their insights, especially on the law field, is always amazing. The newspapers, the social media, all go gaga about their knowledge and insights. Friends who on the platform of this us, as well as on the Facebook, an intruding question would be that who is the sister? They know Pushpendra Singh Bhati. Then the question is Aishwarya Singh Bhati. And both have created their own niche. And they say that when there are two trees, invariably one doesn't grow, the other grows. But to create the space within the space and create their own niche within the profession and the social platforms speaks volume of their background, their pursuit to do social justice. And they say that once you have established as a lawyer, thereafter to become a judge who has an established practice gives only what we say icing on the cake. And once I was which we had shared also on the social media regarding the keynote speaker, I was just seeing, and that paper is also near me, it says he is specialized in writ jurisdictions, service law, public law, election law, revenue, education, panchayati raj, family, criminal, Indian Railways, and a lot of panels. As in Punjabi and Hindi, they say, इसके बाद कुछ और बचा भी है किसी और के लिए space के लिए. Then I thought that the only way of giving space to the professionals was that he had to adorn the bench, and then it created space for a large number of people. And in the profession, it is commonly said that a lawyer who has got good practice, once he is elevated to the bench, the first fact is there's a lot of disposal. And second fact is that a lot of work is generated of the other rung of lawyers, which is healthy not only for the judiciary, but other segments of law. And once we say that we have a speaker with immense knowledge, the only way out is that one shouldn't take much time because all the participants are invariably likely to, and are always more so, wanting to listen to the keynote speaker rather than the person who is introducing him. Over to you, sir.
Thank you, Vikasji. A very good evening to all. In these COVID times, you have really made good out of the time the students of law can spend together by these wonderful platforms like what you have created. We can update ourselves, we can discuss amongst ourselves, and we can upgrade ourselves so that when we are back in the mainstream work, we all are more stronger, emancipated, and with a better upgradation of law. So thank you so much, Vigasi, and I hope that you would not say that the doctors need white and the lawyers need black, so the judge ought to be gray, because gray sheeps are not very good to be at the right. Anyway, it is on the lighter side. Thank you. The topic chosen is of great importance, because public employment, if understood in the right perspective, has a great is a student's is one thing which is a student's paradise, because there is always something to learn in this, and the law keeps on evolving, and the outreach of the law keeps on going like a pendulum, from a very lower pedestal of the job to the highest pedestals of the employment. And public employment, basically, we can say that mostly the definition of state under Article 12, and wherever the stakes of the state are on the higher side, and the state has control over the system of employment, the public employment is generated. The very purpose of public employment was to facilitate a better lifestyle, to facilitate, to empower a common citizen, and to sort of give every kind of facility possible to a citizen in the shape of a service provider, which may be a public employment of any kind, any nature. It is a very vast topic. We will try to synchronize it into the time given. The debate is always going on. On one side, it is said that public employment is a burden on the exchequer, is a burden on the state, so it ought to be streamlined, it ought to be reduced. It creates a lot of, it takes a lot of resources to create a public employment. And ultimately, the answer lies in privatization and the disinvestment and all those fundamentals which have also been propagated all the time. And public employment has always been considered as a remarkable, I mean, as a subject, a remarkable subject of intense studies, not only by the lawyers but also by the by the society. The other side of the public employment is that those countries which are having the highest public employment are the topmost countries in the happiness index and in the satisfaction index, in the parameters of civilized society. I see that those countries who are having larger machinery of public employment are able to deliver it better and more efficiently for a common citizen. And I ask to support this or to say to enrich myself on this aspect. I saw some figures, and those figures were very interesting, that out of every 1,000 persons, in Norway, we have 159 persons in public employment, Sweden 138, France 114, Brazil 111 relevant, US 77, China 57, and India 16. So with 16, we compare, if we compare with Brazil or this Norway, we understand that why these Scandinavian countries are having a the citizen feels more comfortable and the citizen is more taken care of. But this does not mean that we create a huge bulk of public employment, because again, it has got its other side, flip side also. But there has to be a balance. And certainly, in my opinion, there has to be a strong backbone of public employment serving the common citizen of India, so that we have ample security and ample peace amongst the common citizen of the country. Because ultimately they are the service providers. The better they will keep the citizen, the more they will provide to the citizen, the more care is taken for them, the better it will be for the population at large, for the country. So in my opinion, there is no harm in having a strong public employment. And for having a strong public employment, I think my dog, hey, go away. Anu? Sorry, friends. My dogs wanted to join in and give their thoughts on the lighter side. So it is we have to be very careful while studying this subject as student of law, and the laws and dimensions keep on changing. Let me begin with the constitutional debate. In 1948, when this Article 16 and public employment was being debated, the question arose that how much precedence has to be given to the residence part of it, whether any preference should be given by the states to the resident part of it. And also question arose that what would be the meaning of backwardness for the purpose of public employment. These were two core points which were there in the constitutional debate in the mind of the constitutional framers, which were addressed to, while there was a broad agreement regarding the other parts of the Article 16 as it existed at that time. Of course, we have now amendments and we have treated equals and unequal. We have carried further the philosophy of treating, not treating unequals as equals, while treating equals as equals. So the constitutional debate, the framers, they found it appropriate that if any kind of special preference is given in public employment to the local person. Today also all of us as handlers of, while handling the situations of a common man, a common person having public employment, we realize that a lot of, in fact, we had in Rajasthan, we had number of cases where the bonus marks were given for resident for a particular district or for a particular local area. But all those were struck down by the apex court, and it was the same idea which was there in the mind of constitution framers, as they understood that if any kind of localized preference is to be given, then the concept of one country, one union, and one constitution will suffer. So therefore, the question of giving preference to the localized persons or any kind of benefit to them was ruled out, and the concept of backward classes was also debated and ruled out by saying that it is better to have scheduled caste or a scheduled tribe with a schedule within the schedule, so that they are better described, better defined, and a vague term like backwardness was avoided by the constitutional framers. It is another thing that after that, as the society always evolves, so does the constitution and the laws. So as they evolved, it is another thing that there are the other reservations that they entered into the framework, and those reservations were on the basis of the backwardness. We will deal with it a little later. So this was public employment, why it should be there, why it should not be there, world vis-a-vis India, and how we are going to, we should be able to deal with it, because in our country, other problems which are touching us are number of posts in public employment are kept vacant with a thought process that the more they lie vacant, the more to create sort of financial viability. To my humble understanding, this may not be a good idea, because to create the post, to have a post, it is a scientific management of the cadre wherever required, whether it is the doctors, whether it is the policemen, whether it is the judges, whether it is the all of whatever is required in the public employment, from cleaners to municipal employees and to all who are required, teachers and all, everybody who is required. They ought to have been, there is a balanced structure and there is a cadre, and the growth of population has to commensurate, has to correspond with this growth, which is not corresponding, but for fighting out the financial viability, we cannot jeopardize our strength of public employment, because it is not only the strength of the employee concerned, but is strength of our common citizen, which needs to be taken care of. The public employment, the Constitution deals with public employment in Article 16. It deals with public employment in Article 309, 308, 309, 3010, 3011, 3012. But These are the disciplinary part, and the service conditions is one component, and equality in the public employment is another component. We will touch them. And to begin with, let us understand that our today's topic is changing dimensions. So how the dimensions have changed, we will touch few precedent law which has really created the change in the society, in the dynamics of public employment, and then we will move on to concepts like reservation and all. So the changing dimension, to my mind, began with the change in the mindset of the society. And with the mindset of the society, we are not only the precedent law changes, but changed, but the priorities of the society also had to change, and therefore the public employment, the nature of public employment has changed. There was a time when most of the public employment used to be a permanent job, whether whatever profession it was, whether it was a teacher, doctor, or so on and so, it was a permanent job holding a responsibility towards the organ of state, whatever organ it might be, or a public undertaking. But slowly we came in the concept of ad hoc appointment. Slowly, the ad hoc appointment was nothing but it was like something where a peculiar requirement had arisen at a particular time, and that particular function had to be, there was no one to perform that particular function at that juncture. So somebody was given some ad hoc responsibility, and this ad hoc responsibility was a form of public employment. From ad hoc employment, we traveled to, we have also seen urgent temporary appointments. So these urgent temporary appointments were where the actual appointment process was likely to take a long time, and the normal selection process required some breathing time, and there was the work associated need to be fulfilled. So this urgent temporary appointment concept was there in the public employment, and these persons were to fill in the blank until the regularly selected persons or the permanent persons were there. Apart from this, we had co-terminus. We had project to co-terminus with project employment. In this, there were some things which were done as a project. So they were not permanent jobs which were created, but it was suppose some dam has to be made or some building has to be made. So they were those project-based employment in which certain experts like engineers and architects would be required, and labor and mason would be required, and all those persons would be then brought on this platform of project, and then the project would function. And once the project is over, the employment would be co-terminus with it, and no rights accruing to such persons, and such persons' employment in this thing would be given away with. However, the rich experience accrued by them during this process could be utilized for other parts of the other projects which may come up later on. Apart from this project appointment, we had contractual appointment. Now, this contractual appointment is one thing which has become the vogue. It is prevailing a lot in the public employment, and lot of public services. As students of law, we find that lot of public services are being manned by the contractual employees, and this contractual thing broke up in further sections. Like we had contractual, we had service, the employment through service providers. We had contractual appointees as man with machine. We had contractual appointment as a person having the expertise. We had contractual appointment as surgeons. We had contractual appointment as teachers. We had lakhs and lakhs of persons working as teachers on contractual capacity, lecturers, and all from lowest profile to the highest profile, the contractual employment expanded. It was not the wish of the legal experts that the expansion of contractual appointment should take place. And but as we see in the modern times, the state and the public employment has been quite overtaken by the concept of public employment. We see that there are private agencies who are not only providing contractual people on various duties, but we also see that state directly recruits many of the contractual persons on all posts and then this contractual appointment, there comes in a tussle between the employee and the employer, because the rights to the employer are the rights to the employee are very less, and since they are a less protected lot. If a person is entering in the ad hoc category, normally he is knowing that it is for a particular purpose for a short time. A temporary urgent person knows that it is an urgency that he is filling in. And the other mode also, he knows his exact status. Contractual jurisprudence in terms of public employment has not yet attained its finality, as we see how the mode of regularization created a lot of conflict and a lot of litigation in the society. And we see that lakhs and lakhs of cases arose all over the country due to the contractual appointment and the rights arising out of it. In my humble understanding, the public employment, the pay scales and the benefits and the emoluments which were being given to the concerned employees became slowly, it looked like they became unaffordable for the state, and the state itself fell into the trap of spending lesser in employment by giving more contractual appointments on all facets of public employment. The public employment in this sense suffers from a lot of insecurity, a lot of discontinuity, a lot of infringement of a lot of rights, and a lot of problems amongst the in the society. If I may recollect, this public appointment, this contractual appointment also when the person carries on and then he craves for regularization, or for that matter, we may include for this aspect the ad hoc and the temporary appointments also. When they remain in long, then when they remain in vogue for long, they remain in currency for long, then different problems arise. And then comes the situation where the employee starts feeling that he is now having an inherent right to continue and to have better benefits, as he starts comparing himself with a permanent employee, and he starts craving for security at par with the permanent employee, seeking pension, gratuity, PF, and all other benefits, which sometimes were not available to him. Gratuity, of course, is available, but then there are PF also is available. But then in many of the aspects of the security towards the employer, they remained a question mark in contractual appointment, and this type of cases started pouring into the cases in the courts. The lawyers were continuously contesting the rights of these cases, and the jurisprudence traveled from, say, we can say from one end of Pyara Singh to another end of Uma Devi, and so on. And there are a number of cases. We all know all those names but then Pyara Singh on one hand said that contractual appointment should not be terminated. It gave us a concept that contractual appointment should not be terminated by another, a contractual employee should not be replaced by another set of contractual employees. And also, as far as possible, if there is a long appointment which is temporary, contractual, or ad hoc, then it needs to be regularized. And a lot of other cases also developed. This jurisprudence slowly developed. I remember in Rajasthan, the whole concept started in 90s, where the contractual appointees, the lakhs and these thousands and thousands of teachers, they were given appointment as Shiksha Mitra and Vidyarthi Mitra. These were the schemes under which they were brought in, thousands and thousands of persons to strengthen the system of education. But these Vidyarthi Mitra and Shiksha Mitra slowly, when they remained in employment for a long time, then it became a worry for the state, because on one side their long services were there, and on the other side they wanted the benefit of serving the state for 10 years and above. So the state of Rajasthan promulgated a rule which was the Prabodhak rule. I remember I contested those matters. These were Prabodhak rules, and a special cadre, one-time cadre was created and the contractual employees, the contractual teachers, the scheme, they were there in the schemes, they were sort of brought it into the mainstream by giving them some bonus marks and providing rules and then creating a cadre and all that. But then this cannot, the state then ultimately, but it was a dying cadre. It was not created forever. It was a dying cadre. The dying cadre was created to sort out the problem of regularization, to sort out the problem of the long-standing employment, to address the issue of the persons who had manned the crucial posts of teachers and in the rural areas where normally an educated person sometimes shirks away from going or hesitates from going. Those teachers had manned those posts for a long time, and so therefore probably the state found it appropriate to give them the benefit of providing those essential services like teaching, and that resulted into this creation of this kind of dying cadre here in Rajasthan. And I am also aware that many other states in the country have created such posts and have tried to give such bonus marks. I also remember a controversy where initially when the bonus marks were introduced, then there was a huge hue and cry that how far the bonus marks should travel, because ultimately a person would whether it would be 10 marks or whether it would be 20 marks, or can it be say 70 marks. So then again it was a Pandora's box. Slowly it canned down to 30 in legislation in Rajasthan, and then there was a division bench judgment of this Honorable Rajasthan High Court, which said that no, the 30 marks is not good. At best they can be given 5 marks for 1 year, and optimum marking could be 15, which was of course then reversed by the Honorable Apex Court, and it said that giving 30 marks is the discretion of the state. It should be reasonable in terms of marks, and so on and so. So basically the contractual appointment they changed the dimension of public employment to a huge extent, not only in the terms of litigation, not only in terms of the judgments, but also in terms of the financial consequences, in terms of the quality of the service, in terms of the continuity of the service, in terms of the future of the services. For example, one of the leading government hospitals of Rajasthan was having all brain surgeons on contractual basis. So it is not about specialization alone, or it is not about the complicated jobs alone, but it is about the stability of that kind of job, how it would be needed and what would be the future. So slowly, when we saw that higher education was also having the appointments on contractual basis or period basis or on the visiting faculty basis, then it was also a form of contractual appointment, and those became a it became heartburning for the highly educated teachers who on one side were having a regular appointment, were having a very good pay scale, and on the other side were getting the other persons who would be aspiring to become future professors would be getting very minuscule amounts in the form of teaching allowance for a period basis or on the daily basis. So the disparity between the two, was one thing which really, I mean, this changing dimension became very cantankerous as far as the society is concerned, and the person who was on the same foot at one place was completely on the other foot, discharging the same functions. In Uma Devi, the jurisprudence traveled to another extreme, where the courts found that any kind of giving any kind of permanence to the employee without adhering to the regular selection process and without adhering to an open market competition it came into consideration of the Honorable Apex Court that it would give to another set of issues which would arise. And this was because Uma Devi, it was specifically noted by the Honorable Apex Court that in case the person who has not competed in the open market, who has come as a backdoor entry, and who has not been able to fulfill the merit criteria, and who may not be even fully eligible or may not be having the full experience, cannot be held to be responsible, cannot be held to be, he cannot be held to be responsible for holding a permanent post. So slowly this Uma Devi jurisprudence, but simultaneously Uma Devi said that those who have faced open market competition have come in a transparent manner and have come in a regular, are having the regular eligibility and have discharged more than 10 years of service should also be considered for regularization. So while closing the door and sealing it from all sides, a small window was kept open. It is another thing that subsequently the jurisprudence changed, and subsequently the courts again liberalized the public employment by giving heed to the long-time employment which was going on. But then it could not have, again the Honorable Apex Court reprimanded the same ideology, the same thought process, and found that it was not possible in any way to carry on backdoor entries, to carry on regularization, even at this stage, even when it speaks very low for the person who has discharged services over 10 years, 15 years, 20 years. But what to do when he was not having the bare eligibility, or where he did not come through the open competition and came in as a backdoor entry, and providing any kind of relief to such persons for the courts became very difficult. And therefore the judgments one after another came in which said that no, which brought in the jurisprudence that it has to be brought to a rest and the permanent employment shall remain permanent, and any kind of regularization has to be desisted as far as possible. But then again, the balance has to carry on, and it is not the end of the story. It will continue till the contractual, temporary and ad hoc appointments will remain for longer periods. The moment they remain for longer periods, the public employment, that this dimension of the public employment shall ever have to be taken care of, and the public employment shall ever have to realize, it will ever have to face this problem, and there has to be a solutions which the time can only give. Some of the cases which we see around in the panorama of public changing dimensions of public employment are very interesting. We have already talked about Pyara Singh and Uma Devi. Apart from this, we can also touch Article 309, the disciplinary part of it. In this context, I find that the case of Tulsi Ram Patel was one case which changed the jurisprudence and which changed the doctrine of pleasure, and which changed the meaning in the public employment, how far the equity and justice have to be given to a person who is a delinquent, and how far the disciplinary proceedings, what are the rigors and parameters, what are the protection which are constitutionally there. Those formations were discussed at length, and a fine jurisprudence was laid down, which not only brought strength to a common employee, but also gave strength to an employer, as the employer came to know that what were the exact parameters in which he has to exercise his pleasure or exercise his discretions without destroying the fabric of public, the credibility of a employer in the public employment. Some of the other cases that we will quickly, they will reflect the changing dimensions. Like this, we were in the same wavelength as that of regularization in Jagjit Singh's case. I remember this is in 2016, the Honorable Apex Court, while treating the minimum of the pay scale as a benchmark for a person who is there on the temporary employment or a contractual employment, allowed certain relief to those persons, and minimum of the pay scale were allowed to the persons who were discharging this equal pay for equal work, who were discharging the same work and were in the same category. So it became a landmark judgment which provided a lot of relief, and also the various judgments and other states which were followed, and other legislations which were brought in the state, protected a common employee from the state giving them less than the minimum wages or less than the minimum requirement, because minimum wages concept was too less a concept. So therefore minimum of the pay scale became the idea which developed with Jagjit Singh and is likely to develop further. I will also like to discuss a few other cases like Rafiq Masih gave a totally different kind of jurisprudence. Rafiq Masih gave, on one side, the public employment. In public employment, if an employee has drawn some benefit which is in excess to the benefit he is entitled to, then previously in 2002 we had cases which said that such reimbursement or repayment of such payments, such excess payments was not permissible by law. But slowly Rafiq Masih has crystallized it, saying that those persons who are retired, who are class 3, or who are on the lowest pedestal, or who are at the verge of retirement, they need not be, the excess amount may not be recovered from them, and therefore a fine jurisprudence came up to that. As for the other aspect, one more case which one more case which I would like to discuss today is Avtar Singh. From Delhi Police Commissioner to Sanjay, and those other cases, the jurisprudence was that if there was any concealment, then the employment has to go. Then there was a relaxation in that jurisprudence, and that said that if the concealment of the criminal case, or any kind of criminal case for that matter, which would jeopardize the employment of that person, that jurisprudence has also developed into Avtar Singh. And the Honorable Apex Court has said that even if it is a concealment, and even if it is a criminal case, then also a lot of parameters have to be seen. Firstly, if it is a criminal case, then what will be the idea of moral turpitude? What will be the impact of that case on the employment? How far that person can be denied employment due to the pendency of that criminal case? Or what would be the effect of a acquittal? What would be the impact of the acquittal due to doubtful acquittal, the case not traveling beyond reasonable doubt? What would be the impact of direct concealment? What would be these were the questions which came in these jurisprudence, and they completely touched the whole scenario. And slowly we have developed a jurisprudence where we have seen that there are three primary things which have to be taken care of. Firstly, which is the post we are talking for? If it is a sensitive post, if it is a responsible post, if it is a high post, or even at a middle level post, then of course we have to take strict parameters. But if it is at a lower pedestal, then we can have slightly less stricter parameters. And any kind of criminal law, any kind of criminal case alone would not debar an employee from seeking employment. The service rules in Rajasthan, police service rules, they even go to the extent of they are providing that a person who is in prison and his conduct is very good, then probably it is section 10 of the rule of the section of the act, or rule 10 of the rule. Rule 10 provides that if a person is having a good conduct in the jail, then he is bound to have a chance. He is bound to be given a chance to appear for a public employment. So this dimension of public employment slowly changed, and the jurisprudence for concealment and the available criminal cases and the acquittals, and this thing has developed, whereby strong criteria has been now developed. It is not the end of it. We all know it, that it will continue to develop. But a good point that I understand out of the jurisprudence which has come up to Avtar Singh and so is that we have to have. We all know that in jurisprudence in the criminal jurisprudence also we have a reformative theory. Once we have a reformative theory, we cannot blanket ban all the youngsters who may sometimes face some hard circumstances in the shape of some criminal case or some FIR, which may happen due to family circumstances, due to other social circumstances. So we have to. It is not we can have a straitjacket formula that these persons can be permitted and these persons cannot be permitted. It has to be a case to. It has to be. The state government, employer, and the legal students have to look from case to case and find out as to how far the person is entitled for employment and how far he can go. Similarly, we have also seen one jurisprudence in the judgment of Captain Paul and thereafter, in where there were complicated questions of law and complicated cases. We found that simultaneous holding of departmental inquiries and simultaneous holding of the criminal proceedings was not allowed by the Honorable Apex Court. This jurisprudence suffered a reverse jurisprudence, whereby now the Honorable Apex Court in some cases have observed that long pendency of departmental inquiry and inconclusive nature of departmental action gives suffering to the employee as well as the employer, and therefore there should be minimal use of the jurisprudence of Captain Paul, and virtually unless there is a real complicated question of fact and law involved, where the disclosure of the evidence and disclosure of the examination and cross-examination was really jeopardize the criminal trial, it should be avoided that any departmental inquiry should come to an end, and it should be, in fact, it should culminate into finality. Carrying on in the same streak, the jurisprudence of suspension also has undergone a lot of change. Earlier, it was understood that a person against whom an inquiry is, it was a basic law that against whom an inquiry is contemplated, against whom the department requires to take disciplinary resort to disciplinary proceedings, it was decided that he may be kept suspended. But slowly, a lot of judgments we all have seen how this jurisprudence has developed, and courts have reprimanded the states and deprecated the practice of prolonged suspension, because we have seen that for 10 years, 12 years, a person would remain in suspension. In the bargain, he will get all the 3/4 allowances and all the benefits that an employee is supposed to get. And with those benefits, without work, it will do more injustice to the employer, and also sufficient insecurity will be caused in the mind of the employee himself. So therefore, now the jurisprudence regarding suspension is also changing, though until now, the judgments do not give a strict parameter or a straitjacket formula for the time period involved in the suspension, which is another aspect. In the aspect of compulsory retirement also, we've seen a lot of change, as we have seen that in times, the compulsory retirement has two aspects. We all have seen that one is it is punitive in nature, another it is weeding out the deadwood. We will not speak about the punishment, because punishments we may not be able to touch today, and it is not part of the changing dimension. But yes, compulsory retirement as weeding out has become a prevalent practice. It has become more prevalent these days, as we find that if a person is not disentitled for his basic benefits, which arise out of his employment and which are available to him on retirement, are almost at par with his completion of 20 years of service, we go out and we are trying to take a more extended view of the jurisprudence of compulsory retirement and maximum resorting. We have seen that the central government in last 5 years has extensively resorted to compulsory retirements, and though the student of law is always intrigued by the fact that how a compulsory retirement, which is somewhat detrimental to the subject, could be imposed without giving him any opportunity of hearing or without adhering to the due process of law. Though again, it is a tool in the hand of employer to weed out the deadwood, and does not mean any direct harm to the subject concerned. And thus, until now, the jurisprudence is that it can be permitted without adhering to the principles of natural justice. Though the courts have been interfering in those matters where the record of the case do not suggest sufficient material to treat the subject as a deadwood. And wherever it has been a challenge which straight away is put to the employer, and if he is able to do it, then he can certainly go ahead with the concept of compulsory retirement. Apart from these cases, we would also discuss to some extent the reservation. How we have seen the jurisprudence in the public employment changing for the reservation. We have seen Indira Sani, where we had a capping of 50%. We had in Indira Sani, we also had the reservation otherwise conceptually was supported by the Honorable Apex Court, and apart from 50% capping, reservation on some counts were refused also. But then that has developed. Now it is again Now, again, the whole country is looking forward. There are a lot of issues going on. We have seen the Bombay High Court judgment. We have seen the other Rajasthan High Court judgment. We have also seen the controversy arising in Haryana and Gujarat, where we have seen that the economic reservation in Rajasthan, a 16% economic reservation, economically backward reservation is being brought in, because Indira Sahni was at a stage where the socially backward reservation and the OBC, other backward classes reservation was created, and which was upheld by the Honorable Apex Court as a modus operandi. But simultaneously in Indira Sahni, the court did not much agree with the economic reservations, but now the economic reservation also to the all citizens on the basis of the poor economic condition has again become a hot potato, as almost 2 to 3 high courts have given their judgments on this, and the matter comes up before the Honorable Apex Court, and it will have to decide whether the capping of 50% and the economically backward classes and the other sections and bifurcations which are being created can be handled with. Another case of another controversy which hits the public dimension is reservation in promotion, which was quite upheld by the Honorable Apex Court, while in the same breath saying that the data and statistics has to be there with the concerned state governments, who have to realize that in case the number of the corresponding numbers of the particular class are not there in the public employment, are not being represented in the promotional class, then those reservations in the promotion can also be given. But again, it is an open and shut question, because even after Nagaraj, the debate continues that how far the promotional avenues can be tackled as far as the reservation is concerned. So these are the few aspects which we have touched today. The public employment is always it is a huge platform, not only for the litigant, not only for the student of law, teacher of law, judges, lawyers. It is always touching the common man. It is always touching the common man, because if we have the public employment, the better it is, the better quality of life can be provided by the government. It is rather the strong arm of the government which is there, and we all wish that we have a strong, in spite of all the changes in the dimensions, this becomes more smooth. This has to become more smooth, and all the categories and subcategories that they will slowly come in, and they will slowly settle down. And I'm sure that a public servant and a public service and a service law and service jurisprudence will see a more peaceful time in future, as we all continue to contemplate for the same and continue to work for the same on the pedestal of law. Because I think we can open the questions so that.
Yes, sir. So before doing that, I would just like to say that we have been able to connect, and we have amongst us Justice Vineet Kothari, who has been from Rajasthan and now presently the judge from Madras High Court. Before we know that he can off the cuff give his insights. Just 5 minutes for that, when the questions can be posted there, because just, as we said, that it's a rare occasion that we have, it's more like a DB, and giving a view on that point, and just his insights will also facilitate the speakers to have the insights. Now we can say from the Madras bench, though the roots are connected to Rajasthan itself. Over to you, Justice Vineet. We are obliged that you have joined us.
Oh, thank you, Vikasji. It is a great pleasure to listen to my younger brother, Justice Bhati, who is virtually an authority on public employment. And I have known him for last about 30 years now. And you may not be knowing that this was the most powerful service jurisprudence duo couple lawyers in the Rajasthan High Court. His wife, Madam Nupur Bhati, is also equally competent lawyer in service law. And Justice Bhati was, of course, an ace in that. And we are very happy. I joined this voluntarily because I knew that will be one of the most wonderful sessions of your webinars, which have so far happened. And the way I've been listening to him for the last 40 minutes now, and it has been so good on all controversial aspects. It is sometimes difficult for a sitting judge to express opinions because we have our own some limitations. But Justice Bhati so ably done it with his masterly knowledge and deep knowledge, I would say. The way his case laws were flowing from the mouth of Justice Bhati. He has read all these judgments in depth and he can express these opinions very beautifully. He has done that. Well, I have never been a service law judge or a lawyer as such. I was a tax side person. But I have heard Justice Bhati so many times as lawyers in my court also, and I've learned from him. So I would not say anything, but yes, these all controversies of reservation and compulsory retirement and the increasing dimensions of public employment, which in a country like India is a boon for many people. People vie and fight for public employment because the sense of security, the sense of benefits, perquisites and salaries and wages which a employee in government job gets is tremendous. Though Justice Bhati pointed out that in our country only 16 as compared to over 100 people seek public employment in various developed countries. But that is, I think, because we do not have that much of infrastructure and sufficient opportunities for public employment. So we should, I think, provide stability to the public employment more in our country. And then at the same time, I would think that taking output and work from the government servants or public servants is also equally important. In our country, so far, there has been no research or data on the output and accountability of public servants as such. I have been suggesting this in last webinar, in one webinar which I attended a few days back, that there should be a kind of research analysis of the output data or efficiency level of the public servants. We should be able to take work from the people whom we are highly paying or paying nicely. So this kind of research should develop. Now, you know, there are various agencies making research of the output by the judges and judiciary. How many cases we in our subordinate courts, we have the system of giving them units and all these systems. But there is no system of taking the output analysis of, so for say, example, an income tax officer or an RS officer or a judicial officer or whatever. Everybody should be able to measure up to the level in which he is expected to deliver and is accordingly paid. The inefficiency should not be tolerated. Therefore, this public employment balancing kind of thing should develop in our country more. And I think the bright people like Justice Bhati, when they rise up the ladder, will have all these chances to express opinions more authoritatively, that how public employment could be made a more lucrative at one point of time, and then again equally responsible job in a country like India. That would benefit our country more. So thank you very much for these brief remarks. I think Justice Bhati has very, very nicely dealt with all the topics I've learned and I've been learning from this field of the law at least, and is a dear friend to me also. So very happy to have joined here. Now I am seeing some Rajasthan faces, but many others are in the audience also. So let it just open for the audience now. Thank you.
It has just transpired that Justice Dinesh Mehta ji has joined from this thing. I'm just checking it out.
Yeah, Justice Mehta, if he's there, he's also another bright, very bright text side.
So we are unmuting.
Abhinav Sharma.
We are unmuting him and we are unmuting Dinesh Mehta ji.
Yeah, brother Dinesh, please.
Probably not switched on the video.
Okay.
He's unmuted himself probably. Yes, we have unmuted him. Justice Mehta. We will meanwhile unmute Abhinav. Abhinav Sharma is a, whatever I've, through this platform I've learned that he's a young pushing lawyer.
No, very bright.
And I can always say young because a young impression always gives the young people.
It's always good for Vikas to say such high words for us, and he's an energetic force behind all these sessions throughout this across the lockdown period, and we have been sharing common platform on the social media. And my evening pleasures to Justice Bhati sir, Justice Vineet Kothari sir, Justice Mehta sir, and it has been always a pleasure listening to you people over these sessions, sir. Justice Bhati, I would just like to raise an issue regarding, or in fact a question regarding one of the changing dimensions. I mean, with this lockdown period, there had been certain issues with regard to the contractual employment. There had been financial crisis across the country, in fact across the globe these days. teaching sector is one of the sector which probably is the most struck out of this lockdown period. And now even after the lockdown has resumed, most of the teachers are working from home. They are giving online tuitions, online classes and all, but they are actually being at the same time with the financial constraints exploited. That parents are saying that we should not give the fees due to the schools because but I mean some of the schools are online, but most of the schools are not online. Then there are teachers, there are family where both husband and wife are teacher, and they are absolutely dependent upon their salaries being received from the school. Now in these circumstances or these pressing circumstances, what about this aspect of the fraternity, I mean the teaching fraternity, which are actually contractual, and if they don't continue, they are either working on a 1/4 of the salary, or they are working on a paltry sum of some 5,000 6,000 a day in a month. So what can be done on a legal side on these type of this type of crisis for this fraternity, sir?
Dr. Abhinav, you have raised a very pertinent question as always, and the teaching community is a very big community. But to my humble understanding, the challenge of force majeure or the challenge of the pandemic is to the whole society. So it is not only to a teacher, but it is probably to the lawyer also, probably to the businessmen also, and to all chartered accountants also, and to each aspect of the society. I understand that I understand your concern, because we have teachers from the lowest pedestal to the teachers at very high pedestal. So the maximum amount of teaching community being on the weak foot as far as financial conditions are concerned, particularly the private ones, it really becomes challenging. I'm sure the government would evolve some methodology whereby even if some fee concessions have to be given to the parents, then also some bare minimum amount ought to be paid in ratio to the wages which are to be given to the teachers, so that at least their wages continue. Because teaching, as we all know, in the Constitution under Article 21A or in the RTE or in all other laws, it is not only an essential constitutional and essential statutory function, but it is one function which concerns with the strength of the country to the bottom line, to the younger generation, which is 70% of this country. So we can't leave them weak. And Dr. Abhinav, I'm sure the government has to tackle this issue by giving some maybe some relaxation in the fee, but at the same time giving some benefits to the teachers, or maybe even go to the extent of providing some relief of compensation to the schools to be given to the disbursed to the teachers at the lower end.
So in fact, what Abhinav said and your insights, now actually there are wheels within wheels. One is not able, the balance to be maintained. If you ask for the fees from the students, the private institution says that only then we can pay the pay. And if the pay is to be given, then they say fees has to be given. So it is just like what we say, what came first, whether the egg came first or whether the hen came first. That balance of equity, in fact, one of our single judge has taken the view, yes, the fees has to be given. And she had also been on your side of this thing, Justice Nirmaljeet Kaur. She has given that, though the state has joined, though the state have just gone in an LPA, probably it will be listed tomorrow on that particular judgment.
In my humble understanding, like Bar Council took an initiative and did something for the lawyers. However, I mean, it was a welcome step particularly for the struggling lawyers. Similarly, some government can certainly, I mean, even if the students are not made to pay, maybe government can come out and give some compensation to the teachers.
Right.
Yes, sir. So actually, that's what as you said, that once the judgment came of Uma Devi after Pyara Singh, and then they said, then it was for the first time in 2006, a distinction between, we always thought there is only a backdoor entry, but for the first time, according to me, it was carved out that there is a subtle difference between an irregular appointment and an illegal appointment for the purposes of employment. Then while giving that para 43 and 44 saying that you frame a policy, that gave little window that you could do. And then as you said, and Justice Vineet Kothari had said that you had taken us through the wide spectrum of law from employment, recovery, then one of the judgments, at least in our High Court, while creating a subtle difference between Rafiq Masih, was that wherein, relying upon Justice Thakur's judgment, it came out that once you give an undertaking to the effect that the recovery could be affected, the exception carved out was, yes, you could make the recovery. That was the case of from Punjab and High Court versus Jagdev Singh, to the effect that once you give an undertaking, then yes, that subtle difference between the recovery could be done. But one question which, as a lawyer, because I've been appearing for both sides, I've found that invariably none of the judgment relies upon the Contract Act as to whether that payment having been made under what is the effect of Section 72. If the payment has been wrongly made, whether it could be recovered or not recovered, that issue, broader perspective has been done. But yes, as to what is the effect of that Contract Act, let's assume it's just like I think loud within myself, though we have been defending from both sides, to the effect a payment is made to someone in excess. And there are circumstances, though they say that yes, it can be done, but there are circumstances when invariably the person also knows. And one loud thought which our full bench had taken in that view of Budram was to the effect, yes, there is a steep hike in your pay or pension, then invariably a natural consequence is that a person goes to the office, he invariably, not in writing, etc., he will ask why there is an increase. But every windfall for the favorable is always appreciated. So one doesn't mind, one is enjoying that. And so one question, this is by Ravi Singh, he says, government is doing privatization of most of the services earlier run by the government, and rather than hire, employment is provided on contractual basis without job security. What is your take on that?
The whole thing was the biggest change in the public employment dimension is this only, Ravi ji. And as Honorable Justice Kothari also just reiterated, that public employment will always remain a very, very important aspect of not only employment, but governance. And if it is done efficiently, it takes up, I just now pointed out the figures to you that there were only 16 employees in government of India for population of 1,000. Whereas in China, these employees were 57 and Brazil 111. So this shows that our government machinery is not that big, or our public employment, the structure is not that big that we need to worry about it. If we see it by the international standards, and if we see it by the perspective that ease of doing business or happiness index and the other world studies that take place, it will be always important and pertinent to keep strong the public employment. And it is not that like for example, teaching, schools, and the essential other backbone elements of the public employment, they will always, the need in those employments will always be there, and they will always need to be strengthened and need to be empowered by the state. And we need not shirk away from appointing people. This contractual part of it has to be, this jurisprudence is yet to settle. We'll have to see how it goes. To my humble understanding as a student of law, the hire and fire policy, or the policy of giving all the leverage to the employer to engage the employee at its will and disengage at its will, it is good to some extent when you are working in a competitive spectrum. When you are working in a particular business spectrum or competitive spectrum, then it might prove to be fruitful or prove to be more productive. But when it comes to service providing, then the answer is only making it more efficient, whatever the type of jurisprudence, type of dimension it might be. And this is a recent change, so it is still evolving itself, to my mind.
So one thing which I also feel, that as the case law has been evolved, one aspect, though we say the contractual employment, but invariably I've seen that the Contract Act of that 1971, which said that the contractor should have a license, but invariably, rightly or wrongly, large number of people don't touch even in that petition, to the effect that the license was not issued, therefore the appointment by a contractual. And secondly, like if you would recollect, sir, 2002, that judgment of Suresh Kumar, which said doctrine of lifting of veil as who is the principal employer. This submissions to the effect that doctrine of lifting of veil as to whether the principal employer is the government is also not being touched. Invariably, large number of petitions are only to the effect which says that a contractual should not be replaced by a contractual. And as they say that as there are lawyers, the other persons also seek advice, and they also try to vent out a way to scuttle that entire process. And that is why what they will do is they will change the name of the employer, the contractual source of employment, to state therein that after the 1 year, as what you had rightly stated at the first instance, that their job became coterminous since the employer to whom the license had been given for contractual employment came to an end. But as you said, according to me, that these two sources are actually rightly to be evolved as to whether the employment, whether the license and Section 10 of the Contract Act, that judgment of Suresh Kumar, HSEB versus Suresh Kumar 2002, and then to the effect that as to whether doctrine of lifting of veil has to be applied in these circumstances, to the effect to know that the principal employer still remains to be the government, and therefore within the meaning of Chapter 4 of the Constitution of India, as to whether it has been in consonance with that. I can ask Mr. Abhinav, since what has been transpired during these webinars, it has transpired that Abhinav is a person who can give insights. That's what has transpired during all this. What is your take, Abhinav?
No, Vikas is right to an extent. This aspect is one of the crucial aspect which he is highlighting. But at the same time,
just a minute, Abhinavji. I also with Vikasji would like to ask you something.
God.
In extension of the question of Vikasji, my question to you is that now the contractual is moving to another phase. They are saying that we are giving the whole project to a particular agency, suppose some service provider, and then he is engaging on contract. So even if there will be a contract and there will be a contract will be, suppose for example, the security of a hospital, it requires 70 persons. So this service provider, the government is not having any relationship with the person. He only saying who is going to maintain the security. The service provider says, yes, I am going to do it. And then I enter into a contractual relationship with the state. In the bargain, I engage 70 persons, whatever I take from them. In the bargain, I take 100 rupees from the state for them, consume 50, give them 50. And that particular aspect is also. So please add in your answer this aspect also.
Exactly. I was coming on this point only. Not only this, that what Vikas has pointed out. This is another aspect which I was coming to, which your Lordship rightly pointed out, that the state has ventured into a new arena these days. And that is not only a direct contractual one-on-one relationship with an employee, but in fact, they have started soliciting or giving the work with a solicitation to the fact that they should be engaging only service providers. And now once the service providers are engaged, there arises one more complex situation, which my Lord has rightly pointed out, that there is not directly any relationship of an employer-employee or even a principal employee, or even after lifting of a wheel, the contractual engagement remains to be that of a service provider. He is only rendering the services, or he is entering into a contract of getting something done by way of his own means and resources. Say, for example, in most of the offices, these days, the typing work is done by typists or the computer data entry operators. And most of those data entry operators are being provided by service agencies, and they are keeping on replacing one or the other set of employees which they have engaged. But then they are providing a fixed data entry operation. Say, for example, NHRM is one of the best example in Rajasthan and in most of the states, where these entry operations of ambulances and their travels are being dealt in day in and day out. And a huge number of data is there is an input of these data, and these employees are being engaged by them. Now, the issue was rightly my Lord has pointed out is that there is a share cut, and that share cut eventually creates a more complex situation for these type of downtrodden sections which are attached, or which the people contractual. Yes, I must be better saying it as having no bargain power in these situations. So those persons who are engaged and their relationship, that is not being taken care of as of now by the Contract Act. The Contract Act is only limited to a party A and party B and their right vis-a-vis amongst them. And that actually has been very well deduced in the contract which is government is engaging into. Now, see, there are other aspects also, sir, which I will wish to point out, that when government engages these service agencies, there are certain conditions. I mean, government is paralyzed in most of the advances which have come up on the surface with the technology, with the time and the requirement, that government is required to have certain specializations. And those specializations are usually either cost consuming or either time consuming. And in both of these, to become more effective, the government is these days outsourcing most of the work. So therefore, there has to be a sort of, a new set of rules or a new set of legislation with regard to what is transpiring in these changing circumstances with the government. Merely the constitutional provisions of engagement, the contractual provisions of engagement, or the general finance and audit rules which are framed by almost every state for getting these engagement are not proving, to my understanding, to a level of the to catering the situations which are still existing there on record. That's what I would be submitting.
No, that's what I'm saying. Invariably, because as Justice Bhati also said, there are certain issues, like they say, right from Brojonath, etc., that in some cases there are judicial precedents to the effect that it is in breach of Section 23 that you have towed to the line. In certain cases, it's said that you are well understood to the effect that what are the consequences, you are holding a good post. Therefore, in terms of that, Section 23 will not come into being. It is just like somewhat clause, like in MACD, invariably, if there is a license and which is found that the second one renewed is perfect, then invariably, when it goes to a lawyer, his drafting would always say that he had engaged the lawyer, taken a test, and he found that the test was perfect. And therefore, so as they say that wheels within wheels, or they say that once there is a law, there is a law.
What Vikasji is pointing out, sir, is the similar situation which is existing in Dowry Prohibition Act. There is a provision under Section 3 and there are rules which says that there have to be a list of articles which are given at the time of marriage, presented and duly signed by both the bride and bridegroom. So what Vikas is pointing out, having a license and then engaging and then writing it the same way, it is almost, if going by the analogy, almost every second FIR of the 498A must fall, because it invariably says that Streesan has been given and that has not been given back and 406 is attracted. And unless and until the police ask where is the list which you have given, then they are required to be booked under Section 2 for giving dowry as well. So this is the situation which the Contract Act is practically facing, and Vikas is right in saying this, that statutes do contain provisions but that are not being implemented and not followed. And in fact, most of the lawyers, as you rightly pointed out, because they say that there is nothing about this. So similar is the situation like 498. They don't say that we have given this and there had been a contract and we have reduced this entire list of the articles which were given at the time of dowry. Unless and until that be there can't be any FIR.
I would also like to add something to this, Dr. Saab. When the country began its journey, at that time, the industrial laws and the labor laws were always having prominent role in keeping peace amongst the employees. But slowly, with the industrial law and the labor laws, slowly as they were amended and as the times changed and the hire and fire and slowly the industry and everything got up and took up. Then even in the private employment, a lot of changes have happened these days. We have seen those amendments in Uttar Pradesh and Madhya Pradesh, and we have seen so many. So some other day we'll talk about private employment, but today we are on our public employment. But then the concept of Industrial Dispute Act and the concept of labor laws as well is rapidly undergoing a change. I'm sure we'll have to, and you have the dichotomies pointed out by both of you are very hitting. Because these changing dimensions, they are impacting the common citizen. Because ultimately, if an employee is not at peace and is not efficient enough, then it directly is correlation to his delivery of the job that he is supposed to do.
Right.
So in fact, this public employment was always considered to be that aspect, that there should be stability of job, stability of increments. But with the flux of time, but there, as they say, there are lacunas. People in the ID Act, I know that. A friend of mine was a lawyer. He said that he knew someone, one superintending engineer used to always employ someone for 240 days, because at that point of time, it used to be that after 8-10 years, the matter used to come. Deliberately, he used to appoint someone else and tell that person, now you go for the ID Act. So that after 10 years, he said that there is a violation, that junior is appointed and 25F payment has not been paid. So the courts also have to evolve with the advent of time. So we can't say that totally is there, because some people actually, they say, as they say in the lighter vein, they say that where there is a law, there is a flaw, and when there is a flaw, there is a lawyer. And in the lighter vein, they say that in the lawyer's office room, it's written that, and that lawyer has to be me. The issues can continue. One is by Siddharth Mukherjee, posts on the Facebook. Sir, if a probationer during a probation is discharged simpliciter due to concealment of a material information, can he be reinstated? Though he says labor tribunal, I am saying I go a step further.
The important aspect in this question would be that what is the post and what is the impact of the concealment? These two things have to be looked into. Suppose, to my mind and to my humble understanding as a student of law, if the concealment is not impacting the eligibility, you know that now the Supreme Court has come down very strictly that those persons having caste certificates or any kind of eligibility certificates which are not correct or have been concealed, then they need no mercy. But similarly, if the concealment is having no impact on the eligibility of the person, and if the class of the person is such where concealment can be, suppose, for example, you are dealing with a class which is very lowly educated and they would not understand the technicalities of the nitty-gritties of the filling of the form, and there is some mistake on their part, then this kind of concealment can be ignored, it can be excused, it can be let away with. But on the other hand, if the concealment is material, suppose, for example, if A gives an age, a wrong age, which makes him eligible to the employment, which otherwise he would not be eligible, then such concealment has to result into his going away. And if the age was immaterial, that means he is showing his age to be 23, but it should be 24 or 22, but it will have no effect actually, even if it is there, actually there, it will have no impact on his employment, then probably it is for the employer to then probably ignore it.
Probably in that case, what you are trying to say, I can unmute Abhinav because Abhinav is also giving good insights. Then in that probability, the courts invariably take into principle three issues: doctrine of proportionality, Westminster principle to the effect, and what is the effect, whether it goes deeper to the root of, or whether there is a conspiracy. Because at least I have experienced one thing during all this time is that sometimes it so happens in the question form it's written whether any FIR is lodged, even though that he says he knows that it could be acquittal. The first brush, a person who is not having legal acumen or the knowledge, it could be that simpliciter asking by them that whether FIR is lodged, it means they feel that it's a death knell blow and a knee jerk, that his services he will not be given a job because he has mentioned that FIR is lodged, even though the intent is not there. Or let's assume, because sometimes the column is ambiguous, it says whether FIR lodged, because the effect is that he stands acquitted. Sometimes it says you could have disclosed that FIR was lodged, and because the column is short, it does not say that whether any you have been acquitted. It is an objective type of question, not a subjective type of question. So I have felt that there are certain ambiguous questions also in sometimes the form, because it's simpliciter says whether FIR lodged. Now FIR stood lodged, but he cannot explain that he stood acquitted. Now the dichotomy in the mind of a person is whether he has to write that he stands acquitted, but there is no column. But if he doesn't write that the FIR is lodged, then also it's a dilemma. So it's more like a catch-22 situation. He doesn't know from where to pull it up. I can ask Abhinav what is his take, and then we will ask sir what is the situation in such like circumstances.
Because there is one interesting case which I dealt with. That was a case from a student union leader. He was not knowing that he was having some criminal case pending against him for blocking the roads, a roadblock case. He wrote that there was no criminal case pending, and when an inquiry was initiated, and after being come to the conclusion his services were not, his form was rejected. So then we contested this matter. But there are situations, you are right that way. There is a catch-22 situation. Even people who are literate, who are most educated, while filling up the form, they falls into a dilemma. And now the thing is that disclosures means, there has to be something in forms itself. If it is by the recruiting agencies or the RPSC, in the state of Rajasthan, Public Punjab Commission in there, or any other state commission, they should specifically mention that this is just for collection of information. It usually says that about you, that column contains this form clause, whether criminal case is pending. It comes into a form of a running periodical of those seriatim, where they have been asking questions in fire round to you in the form. So if that contains specifically that this is merely for collection of information, people would not be hesitating in disclosing them. Say, for example, most of the cases, as your lordship might also appreciate, that in the cases of constable recruitment in Rajasthan and in other cases, these lower strata people who are appointed in class 4 or class 3 of the ministerial services, there are situations most of the time we face is that they don't disclose. Usually, literally they don't disclose, concealing it, saying ki, oh, something is would be read adverse to me. There you are right. I mean,
sir, this is a primarily suggestion, or what we can say. It's not a question directly. Himanshu Kanda says, why reservation is given rather than benefits of education allowances and other subject matters. Many students don't get job only because of reservation, and it sometimes becomes depressing. Is there any solution or take to that?
Yes, definitely, Himanshu. There's no cause of being feeling low about it. See, the basic jurisprudence of 16 goes that two unequals cannot be treated as equals. So once the society has recognized that there is a inequality amongst a strata of population, then bringing the unequals to the, treating them as equals would not be appropriate. So these things are not, these are the constitutional framers, since the debate thereon till now, this debate has carried on. It was for 10 years, then it has been continued. Someday if the, although it is very difficult, but that someday if the political class or the democracy or the citizen of this country feels that all have become equal, or we have attained that level of awareness and education, certainly these things can go away. But until then, until the society realizes that there is some kind of inequality which is still prevailing in the society, it is always good to give them that share, that preference, so that at least they can be given an opportunity to come up. This is merely a constitutional opportunity, and nobody, should be feeling bad about it.
So just Abhinav has sent a text that he has to leave for a TV debate. So from one live show to another live show, that only speaks volume of the fact that Abhinav is quite popular. So meanwhile, I take one question. Abhinav, it was nice connecting with you.
Right. Thank you very much. I take leave, my lords.
We will connect after the you are live off the TV. Then we will catch up on the mobile phone.
Right.
So Satish Datta, he has posted on the mobile Facebook whether government would be justified in dismissing a government employee who procures government job on the basis of a forged caste certificate and remains in service for about 10 years till the factum of dubious or a forged caste certificate is revealed.
Now, the latest Supreme Court law says that any forgery or any wrong certificate which becomes the basis of the employment, if discovered at any time, can really become a cause for terminating his services without having any sympathy towards him. And so law regarding this is very stable. It is very, but there is another aspect to it. If it is not a caste certificate, and suppose there is another mistake which has happened, suppose while filling his form or during his employment, some mistake has happened, then there are certainly judgments which say that there are mistakes. If it is a bona fide mistake, it can be ignored. But giving a wrong caste certificate cannot be termed as a bona fide mistake. It is a knowing, the person knows the consequences, and one can't change the eligibility by concealment. If he changes the eligibility by concealment, it becomes wrong. Normally, as a student of law, I would not be talking of any thing which is under adjudication before me. But I would share one judgment which I just gave 5 days ago, which is pertinent to your answer also. That and also the point raised by Vikas ji, that these were persons who were sweepers. So in appointment in municipal corporation, they were supposed to give the details of their children, and any person having more than 2 children was debarred from having the employment. So these persons wrote 2 children, and then all of them, but the rule requiring the rule having causing debarment to more than 2 children, employees having aspirants having more than 2 children, was struck down by the division bench. So the municipal corporation stand was that even if the rule is struck down, they have concealed the information of the 3rd child. So while adjudicating, I don't know whether that judgment is going to be affirmed or whether it will become law or not. And we all know that judgments keep on changing. Jurisprudence has to develop. Somebody may change it, reverse it, or uphold it. Anyways, it doesn't matter. But in my humble opinion, my judgment was that this was a class of sweeper which was less educated, less aware, and the concealment has not has not affected his eligibility, because even if he had disclosed his third child, then also Rule 9A has been taken away by a division bench judgment. So in any case, he was entitled to remain in job. So my opinion in that judgment, which I have rendered just 4 days ago, was that you are still entitled for judgment because of two reasons. One is your class, that you have belonged to a lower pedestal where you are not supposed to know much nitty-gritties. And secondly, the concealment of the third child would not impact your eligibility.
So just adding to that, at least in our High Court and even the Supreme Court, we have seen there are certain judgments. The subtle differences as to whether there is a negligence or a misconduct. If it is a misconduct, then they say you are to be shown the door. If it is a negligence, they say that there's a subtle difference. Let's assume you are asked to perform to a particular duty and you're not coming forward to that. That could be a negligence. But a misconduct is that if you are doing with a malice, etc. That's whatever as a student of law we could have gathered. And the certificate, they are asking the judgment. One Kumar Madhukar says, what is that judgment of regarding wrong certificate? Off the cuff, I remember that was the judgment of Madhvi. So you can share with us.
I have it in my, just within 2 minutes, pass it on to Vikasji after the program.
Yes, sir. Because that judgment of Madhvi said there were two sisters, one had passed and one was about to pass of the scheduled caste. Then they said, one who has passed, she will not be given the benefit of the scheduled caste for all times to come because it's a forged one. And second one was, they said that since she's in the infancy stage, she has to be shown the door. That's what I recollect off the cuff. This is by Azad Singh. Yes, sir.
Because the Avatar Singh, probably in para 32 or somewhere, Honorable Apex Court has said that you will also have to see the class of persons you are dealing with. If you are dealing with a higher class, they are supposed to be more aware, and their negligence can very soon pass on to misconduct. Whereas if a person belongs to the lowest pedestal and a very less educated person, then even if it is, then the thin line between the negligence and misconduct can be given some elasticity, flexibility.
So it's just like, I remember, like 1990 Supreme Court, it said that experience is equivalent to a qualification. Experience can be considered as a qualification. Then they said, if you are a sweeper, let's assume you are 10th passed and you are not, you are 8th passed, then they said the experience will be equivalent to this thing. But they, right, at the same time, the subtle difference which they created was, let's assume a compounder is doing a lot of work for a large number of years. Then you can't say that since he was performing the duties akin to a doctor, prescribing medicines, etc., that with the flux of time, he can say that, yes, I am equivalent to become a doctor because I have been performing the same duties. Because some places at the extreme rural, what we see in the TV, etc., they say that they are performing. So that was, I'm not remembering the exact judgment, but it said that the subtle difference between these two qualifications would be experience is equivalent to qualification. For a class 4, a sweeper, peon, etc., it is equivalent to qualification. And that is what Gujarat Laburam also said, that experience would be equivalent to qualification. So this is by Azad Singh. Nowadays, we had seen in many states like UP, in which government announced recruitments or employments, candidates have submitted demand drafts or IPOs on an average of rupees 200 to 300 as application fees. After that, recruitment comes under the controversy or scam. Government is only interested in taking fees and not in finally giving employment. Likewise, government is playing with the future of the children, which ultimately have negative effects on the economy. What is the solution to such a process?
My dear friend, most of the recruitments in such circumstances would be the fee should be carried forward. Normally it is. If it is not being carried forward, such demand should be made that whatever fee was taken as a form fee for a particular recruitment, even if recruitment happens after 2 years, 3 years, or 4 years, somebody who was entitled then should be entitled then. And this entitlement includes his fee and all other expenses that he has borne. It should be shifted to the next recruitment to avoid causing double jeopardy, financial jeopardy upon him.
But I think, so what you have rightly said, invariably, whatever as a student of law we have learned, is that when the selection is squashed, they don't allow the new persons to do. They say, go with a fresh process amongst that candidate and make the selection process fair. And let's assume even if it is given, then they say give age relaxation and consider the larger persons, but those who are already there, let them be considered fresh. So we have Mr. Ramesh Purohit. He's from your Rajasthan. We are unmuting Mr. Ramesh Purohit because last time also he had joined when Justice Ahluwalia joined. And I've learned that we will take his takes before we...
Definitely.
Yes. Mr. Ramesh ji, unmute kar lein Ramesh Purohit. There's one Ramesh Purohit.
Yes, Mr. Ramesh Purohit, why don't you say something? Vikas ji is remembering you.
Ramesh Purohit.
I can see him on the screen, but he
yes, so we have to unmute him. Ramesh ji, unmute karo. No, with the photo, video on. Video on.
With the coming in of technology, we have all the fraternity has learned to use it in the COVID times more. But then we still need to, keep on upgrading ourselves. Probably Ramesh ji must have.
That's right. So be that as it may, as what we had initially, they say, what is the difference between belief and the truth? Belief was that the session would go well. And the truth is that actually it went off well. And the moment we were connected with you for the purposes of giving the insights on a topic, when you were taking up the topic and discussing the various prospects, thereafter, in fact, I realized that I've given you an ocean to handle within a short span of 45 minutes. But that could have only been done once you have yourself an ocean of knowledge. And that fact, when we had connected to you, is this. It says that once is that somebody tells you this could be done, and another is once you actually realize it. The difference between the fiction and truth has actually been realized today, that the fiction within the mind which was created was that you could perform well, but the truth is that you have shown it is the same way as we say that sun rises from the east, and the same way you have projected that once you have deep knowledge, you can touch any topic in whatever time space you can give. As they say, time is like a gas. The more space you give, the more it occupies in the vessel. The less space it gives, the less you've done. But in the compressed form, in that capsule form of the knowledge, what you have given would always be remembered by the participants on the Facebook as well as on the platform. And needless to say that those who stand connected with us on the YouTube. Mr. Ramesh Purohit has ultimately unmuted. Before that,
hello.
Yes, sir, Ramesh ji.
हाँ नमस्कार सर. पाटिल साहब नमस्कार.
नमस्कार रमेश जी, बताइए. हम तो बहुत देर से सब लोग आपको याद कर रहे हैं. विकास जी बहुत देर से आपको बार-बार
इस सिस्टम से निकलने में थोड़ा सा परेशानी हुई थी. सर मेरा एक क्वेश्चन है.
बताइए.
आपने सबकी बात की. आम पब्लिक, मेरा एक आम पब्लिक की तरफ से क्वेश्चन है, जो अभी स्कूलों का जो चल रहा है सिस्टम, स्कूल सारे अभिभावकों से फीस लेना चाहते हैं और उसके लिए स्कूल बंद है. नंबर 1. नंबर 2 सर, उन स्कूलों में ऑनलाइन पहले सिस्टम तो था नहीं. अब ऑनलाइन के लिए सारा भार अभिभावकों को पड़ रहा है. उनके लिए सारी सुविधाएं उपलब्ध कराओ और वही फीस उनके द्वारा लिया जाना साहब कहां तक उचित, उसके लिए भी कुछ.
रमेश जी, अभी इस बारे में काफी बात विकास जी ने और डॉक्टर साहब ने करी. डॉक्टर अभी ने,
मैंने सर सुनी उसको पूरा. मुझे लगा कि केवल टीचर्स के लिए है, स्कूलों के लिए है.
हाँ, डॉक्टर अभिनव
आम लोग हैं.
विकास जी ने काफी विस्तृत चर्चा आपके बताए हुए मुद्दे पे करी. मेरा मानना भी उन लोगों की तरह यही है कि इसी मामले के अंदर एक तरफ अगर शिक्षक को आवश्यक है तो उसकी रक्षा भी सरकार को करनी पड़ेगी और एक तरफ अभिभावकों की रक्षा भी करनी पड़ेगी. और इसके लिए कोई बीच का रास्ता निकाला जा सकता है जब फीस में पूरी छूट सरकार प्रदान करे और साथ ही जो है वो अगर किसी टीचर को जो वास्तव में जरूरतमंद है, तो जैसे जरूरतमंद को जैसे बार काउंसिल उसको एड करती है, उसी तरह उस गरीब टीचर को भी सरकार जो है वो एड करे और उसको मजबूत बनाए. और जहां तक टेक्नोलॉजी का सवाल है, उसका वाइड यूज स्कूल्स को करना चाहिए क्योंकि ये आने वाले समय का परिचायक होगा. धन्यवाद.
नहीं सर, वो ठीक है. लॉर्डशिप ने बिल्कुल सही बताया कि टीचर्स को, स्कूलों को कुछ पे करना चाहिए क्योंकि उनकी फिजिकल उपस्थिति है नहीं, ऑनलाइन पढ़ाएंगे वो. वैसे के वैसे आम पब्लिक को भी कुछ छूट मिलनी चाहिए उसमें से, ताकि वो भी फीस पे कर सकते हो. उनकी अर्थिंग भी वही स्थिति है, आम पब्लिक की.
बिल्कुल मिलनी चाहिए.
Thank you, Ramesh. Sir, tomorrow, for all those participants who are connected with us, in that pursuit to give insights on the various issues of law. Tomorrow we have the topic Law of Writs. The learned speaker would be giving insights, the subtle difference between Article 226, somewhat 227, and then Article 32. We would be having amongst us Dr. Milind Sathe, the President of the Bombay Bar Association, who is an avid speaker, having immense knowledge, and has been the President of the Bombay Bar. As we all know that Bombay Bar is a vibrant bar where knowledge is being disseminated not only one platform, and they were always sharing this knowledge. During these lockdown times, I saw that they have a Bombay Bar Association, very widely issues being dealt with, a lot of webinars uploaded on the, not webinars, in fact, a lot of seminars and a lot of discussions being discussed on those webinars. So do stay connected with us for the tomorrow's session. We have continuous sessions coming forward. And sir, as I said initially, as well as at the end, that it was an insightful session, and the way you gave that sea of knowledge, or the ocean of knowledge. And I only believe that you had that ocean of knowledge, but you shared with us the pearls of wisdom and pearls of knowledge, which will always be cherished by us in our memories and hearts forever to come. Thank you, sir. Thank you, everyone. Namaskar. Stay safe. Stay blessed. Namaskar.
Thank you.